I have a great panel here today, and I'll introduce them in just a minute. I want to also say that I'm actually, Richard Metzger is with me because he had technical difficulties, and so you'll see us switching the camera around. But since we have a long history of working together both at the FCC and at our law firm, I think we'll do fine. So Richard Metzger served as the deputy chief of the Common Carrier Bureau during the initial phase of the FCC's implementation of the 96 Act and was responsible for the policy and program planning and competitive pricing divisions. And following his departure from the agency in 1998, he was in private practice in Washington for 25 years and retired at the end of last year. Greg Rosston is the Gordon Kane Senior Fellow at the Stanford Institute for Economic Policy Research and also the director of Stanford's Public Policy Program. In 1996, he was serving as the deputy chief economist of the Federal Communications Commission and the chief economist of the Common Carrier Bureau, and most notably had an office next door to Commissioner Gomez, who was before she was a commissioner. During the first year of the FCC's implementation of the 1996 Act, Richard Welch served as chief of the Common Carrier Bureau's Policy Division, and that had responsibility for many of the Commission's rulemaking and adjudicatory proceedings under the statute. He then served 6 months as deputy chief of the Common Carrier Bureau before spending the next 20 years defending the FCC's decisions, including 1996 Act decisions and others before the federal courts. He retired from the FCC in 2021 and now lives in North Carolina. And finally, Chris Wright was Deputy General Counsel of the Commission from 1994 to 1997, and then General Counsel from 1997 to 2001. And in both roles, he was involved in ensuring that the legal analysis of the Commission's orders was sound and in defending the orders on appeal. And he's been a partner at HWG LLP since 2001. All right. First question goes to Richard Metzger. Richard, once this pivotal legislation passed, it was time to get to work. Was the FCC prepared for the challenges it faced in implementing the new statute?
We probably were better prepared than we thought we were at the time. I think the Bureau the Common Carrier Bureau, as it was known in those days, had several things that gave it some advantages. Above all, it had a professional staff that had a detailed technical understanding of how the networks operated and what the various functions in the network were, and that was essential to devising a scheme to bring competition to the local market. Second, it had an institutional knowledge of managing the transition from a monopoly marketplace to a competitive marketplace, based on their experience in the deregulation of the CPE. CPE is the shorthand for the telephones, the actual devices, and then the long distance market. And then third, I would say, Congress, thankfully, at the same time they passed the 1996 Act, they passed a supplemental appropriation for the FCC, and that enabled us to hire a bunch of young, aggressive lawyers and other professionals who brought a lot of energy and enthusiasm, which we really needed to meet the challenges of the deadlines that were established by the Act. So I think all of those were, one more thing let me mention. We also knew going in that at the time, the Chevron doctrine, at least in theory, required the courts to give deference to the FCC in the first instance when the FCC was exercising its technical expertise. And this statute was all about technical expertise. So that gave us confidence, because we knew going in any significant decision was going to be appealed by somebody. So the margin that the Chevron doctrine gave us some reassurance. And I think all of those factors contributed to the ability of the Bureau staff to develop a comprehensive record, and craft quality draft orders for the commission to review.
Thanks, Richard. Now I'm going to ask Greg to turn to the substance and a more economically oriented question here. There was a transition from analog to digital, and there were silos between industry segments that were breaking down, as was described in the first panel. But the last mile bottleneck persisted. What did you and the commission do to improve the odds for new entrants and competition?
So first, thanks for having me on the panel. It's good to see Commissioner Gomez again. There were lots of late nights with the team in 1919 M Street. And I want to give, Richard just said about having a great team and people to there. I remember going into the first meetings in Reed Hunt's office with you, Ruth, and Richard, and thinking, oh my God, I had this, here's my copy of the 1996 Act. Years later, it's not nearly as dog-eared as it was in those first meetings where Richard knew every single section and every single thing and would quote them all to us. That was where the team was prepared. And I thank you guys for doing that. So I just come from auctions, which were sort of the economist's dream, harnessing market forces to push towards efficiency and competition. But we also learned, we knew that we had to have guardrails to prevent anti-competitive behavior. And so in the Act, there were two main pushes for local competition, these silos, that we wanted to get competition in local before we opened up the local companies to get into long distance, these silos. And one was facilities-based competition, and the other was sharing the economies of the local incumbent providers. And the second one was kind of really where a lot of focus went into unbundled elements. Sharing them and pricing them. And there'd been this kind of thing called TS Lyric, total service, long run incremental cost, that would split local and long distance services over the shared line. But unis were going to be a thing, a piece of it. And so Joe Farrell and I came up with a new name, total element long run incremental cost. And Joe was pretty proud of getting telephone into that. The TEL part, kind of quaint now that we think of it as a telephone. And while this had solid economics, it was, and it took all the heat and light of it away from the facilities-based side, which was kind of disappointing because the long run, you wanted facilities-based competition. And we made one really critical change in my mind to get facilities-based competition. And that was in the reciprocal compensation for the exchange of traffic. One Arbach economist came in and told me that them paying 1 cent a minute to other networks for sending them traffic and the other network paying them 3 cents a minute for receiving traffic was reciprocal. So if you remember, this is a small detail, is we changed the reciprocal to symmetric. And so that 1 cent each had to go each way. And the incumbents thought that the world of competition was going to be this nascent cellular service which had very high prices and mostly outgoing calls to networks. So they started with high interconnection fees, and they did not see the new world of internet coming in with ISPs like AOL. And the CLECs that started came in and said, wow, we can get all sorts of traffic coming from the Arbach. And this was competition that pushed the interconnection fees down to cost. It was kind of harnessing competition back again in the same way. So I think that the piece that we really did was trying to harness competition to come back to be the basis rather than regulation, to work with the market as much as possible. Even though everybody's attention was directed towards this other piece, this got through and is the kind of the result of now we were able to get wireless and VoIP in much sooner than otherwise would have happened, I think.
Thanks, Greg. Chris, turning to you. You knew that every major decision by the commission would be appealed. What did you and your team do to increase the chances of success? And What's your view on Richard Metzger's take on the importance of Chevron deference?
Thanks, Ruth, and thanks to Commissioner Gomez for giving me a reason to review all the litigation that resulted from the 96 Act. So I'd been at the FCC for 2 years when the 96 Act passed, and the most important thing I'd learned is that the best brief is a good order. I also knew by that time that there were really excellent lawyers around the commission, like the two Richards and Ruth on this panel, and that a lot of them were fully up to speed on what would likely be the most contentious provisions in the Telecom Act, which was a long list. But I knew that despite all of these tough deadlines to meet, we really had a team that was as well prepared as could be to meet them. We had also in OGC analyzed the commission's losses in the courts of appeals in the early 90s. Mac Armstrong led that effort. And it was clear that the commission often failed to, quote, show its work, unquote. And I know that this was something that Richard Metzger and others took to heart, that you couldn't have an order that just said, here's arguments on this side, here's the arguments on that side, we choose X. Even the arbitrary and capricious standard requires more than that. The commission needs to explain why it thinks one party has a better side of the argument. It was also the case at that time that the commission had a reputation as being the waiver commission at the DC Circuit because it passed a lot of inadequately explained waivers, which suggested that the agency had one rule for parties it likes and another for everyone else. So Bill Knauer, as general counsel at the time, and the bureau leadership organized a series of meetings with commission staff involved in drafting orders in order to try to avoid past mistakes in drafting the many orders that resulted from the Telecom Act. And as Richard just mentioned, we knew that the Telecom Act was a statute. I think it was 110 pages of the statutes at large. And so there was going to be a lot of statutory analysis. And so it was important for commission staff to understand Chevron deference in detail. And again, the key point which arose out of the other study was to look at these orders had to explain why the commission was choosing one interpretation over another when the text was ambiguous, as it frequently was. I always thought that agencies should not invoke Chevron in their orders. The orders should explain why the agency thought its interpretation was the best interpretation, and let the agency's brief add that interpretation was entitled to deference, sort of in the following order. And the brief would say, the commission has chosen the best interpretation, and then at the least it's a permissible interpretation subject to deference. I'd go on for a while about examples of thinking that I didn't really get a whole lot of deference while I was standing at various panels or in front of various panels across the country defending the orders. But let me make one comment now before for the benefit of the future. Of course, agencies cannot invoke Chevron anymore. But I think that makes it all the more important for an agency order to explain why it thinks its interpretation of the statute is the best interpretation. In Loper Bright, while overruling Chevron, the court acknowledged that agencies have technical expertise that sometimes warrants deference, and especially when interpreting a new statute, agency may have particular insight into what Congress was doing, as was the case in the 96 Act, and as isn't the case a lot when an agency discovers something new in a 50-year-old statute. But anyway, the lesson for the future, I think, is that courts will pay close attention to what an agency says, although they won't defer unless they're actually persuaded by the agency's explanation after Chevron's been overruled. And remember, appellate counsel cannot offer post hoc rationales for the agency decision in its briefs, although we sometimes do. But the rationale should be in the order to be most effective. So I think should give Richard Welch a chance to weigh in at this point.
Okay. I'm going to ask Richard a question, and then if he wishes to elaborate on what you said, he's welcome to do that. Richard, you're the one person here who was involved both in crafting the commission's policies and then in defending them in court. And as has been noted on multiple occasions today already, the act was ambiguous in places. How did that affect the rulemaking process and then court review?
Well, thank you, Ruth, and thank you to Commissioner Gomez for organizing this event. I'm coming to you from North Carolina, and I can report that people down here are not pausing their daily lives to celebrate the 30th anniversary of the Telecom Act down here. And apologies to Greg, but they're not pausing on the street corners in Raleigh to argue the merits of Telric pricing. They're more concerned with college basketball this week. So how did ambiguity affect the implementation and the litigation of the 96 Act? It profoundly affected it. It was huge. And it affected it, I think, in at least 4 ways. First is it injected significant delay into the implementation of the FCC's decisions. Some of these court cases dragged on for years. They went up and down the courts. Sometimes they went even up to the Supreme Court. So there could be years before the FCC's order actually took effect. So significant delay caused by the ambiguity in the statute. The other thing it did is it imposed significant cost. The amount of litigation under the Act was just staggering. For the first 4 or 5 years, I tried to track every single appellate decision that came out from every court around the country interpreting a provision of the 96 Act. And I got into the hundreds. I had 3 volumes of it, and I finally just got overwhelmed. I had to give up. And when I think about all the money that got paid to lawyers and economists to litigate those cases, it's just enormous. I've often thought some doctoral student in economics should do a dissertation and try to quantify the amount of legal fees and the economist rates that got paid in the litigation. It would be staggering. Another thing the ambiguity did in the statute, a lot of people took the position, and not without some basis, that the ambiguity in the Act transferred too much power and discretion to the FCC to implement what it thought should be done rather than implementing the Act. And then finally, the ambiguity in the statute gave a few judges, I won't name any names, but I think it gave them the running room to impose their own policy preferences on what the statute should mean. So that ambiguity had a profound impact on all of that. I will never forget, as long as I live, the oral argument in the Supreme Court where the local competition rules were being challenged. And Professor Larry Tribe was there presenting argument on behalf of some of the challengers attacking the FCC's rules. And I can't remember, he used a phrase, he was trying to say that the statute precluded the FCC from taking some of the rules that they put in place. And he used the phrase, Congress spoke with precision in the 96 Act. He used the word precision. And I thought a bolt of lightning went through Justice Scalia's body, and he was going to come over the bench at Larry Tribe. And he said, precision? Precision? You think this statute is precise? And Larry Tribe was kind of taken aback, and he said, well, maybe Congress didn't speak elegantly, but they were precise. And then the opinion comes out, and the memorable last paragraph of the opinion. Remember, the opinion reversed some of the things the FCC, but affirmed some of the things the FCC. And Justice Scalia, speaking for the court, concluded his opinion the following. This is a direct quote. It would be gross understatement to say that the Telecom Act of 1996 is not a model of clarity. It is, in many respects, a model of ambiguity or indeed self-contradiction. That is most unfortunate for a piece of legislation that profoundly affects a crucial segment of the economy worth billions of dollars. He went on from there a little bit. And I'm convinced that that paragraph was a direct response to Larry Tribe saying that Congress spoke with precision in the argument. And the postscript to that opinion was Representative Billy Tozen from Louisiana was one of the leaders in the House to pass the legislation. And he gave an interview to a magazine shortly after Justice Scalia tore into Congress and the ambiguity in the act. And he said this, and this is also a direct quote, "It's one of the most honest things I've ever heard a politician say." In response to Justice Scalia's criticism, he said, "I've said my mea culpas. We made the act as clear as we could politically. If we wrote a statute everyone understood, no one would like it." I just thought that last part was brilliant. If we wrote a statute everyone understood, no one would like it. So as there was ambiguity throughout in key provisions, and as the prior panel, the legislative panel, was talking about, the act was a huge political compromise. The Bell companies desperately wanted to get, ironically, they wanted to get into the long distance business. They thought that's where all the money and the growth was going to be. And they had, in return, they had to give up their monopoly and open up their networks to their competitors. And so that compromise led to a lot of the ambiguity. I used to do an annual presentation to the lawyers about the appellate case law. And one year I put a slide up on the screen that said, political compromise leads to statutory ambiguity. Statutory ambiguity, in turn, leads to litigation. And litigation, in turn, leads to vacation homes, luxury automobiles, and fully funded college funds for attorneys and economists. And it's true. I also remember at my very first oral argument, which Chris Wright took a big gamble and let me do down at the DC Circuit, threw me to the lions. It was an argument about the proper interpretation of Section 271, long distance entry for the Bell companies. And the Bell companies were taking shall we say, a rather aggressive interpretation of Section 271. And the argument's going on, and the judges are getting sort of irritated with grappling with the statutory language. And finally, I got up to the podium and I was talking, and I thought I was about to make what I thought was a rather profound point. And Judge Silverman cut me off. And he said, "Counsel, who wrote this statute?" And I went, "Excuse me?" He said, "Who wrote this statute?" And all I could think to say was, "It wasn't me, Your Honor. I didn't do it. Maybe some of the attorneys or lobbyists in the gallery wrote it." And then it wasn't my fault, Your Honor. And then it just kind of welled up inside of me and came out. I said, "And after 3 years of grappling with this statute, I feel like I've been ridden hard and put away wet." And he just busted out laughing, and it broke the tension in the room. But that's just another example of the ambiguity in the statute that was pervasive. I guess I can't let it go. Sort of responding to Chris saying he didn't think he always got deference from the courts. There was also the infamous case involving the local competition rules that started in the 8th Circuit in St. Louis. And we got the opinion, and the 8th Circuit just blew us out. And they said a particular provision in the act was a fence that was horse high, hog tight, and bull strong. Now, those who knew me at the FCC knew I used to like to use animal metaphors and canine metaphors to grapple with tough legal issues. And while I thought the Eighth Circuit was grievously wrong in the law, I was just in awe of this triple animal metaphor they used. It was a equine, bovine, and swine metaphor all wrapped into one. And of course, Justice Scalia reversed the Eighth Circuit, and I think he kind of mocked that metaphor in his opinion. But there wasn't a lot of deference being bandied around out in St. Louis, I can tell you that. I guess I'll stop there and let others pick up from there. But that's how I saw ambiguity affect the implementation and the litigation in the statute.
Thank you. Chris, would you like to respond or elaborate on anything Richard said? You're on mute, though. You're on mute, Chris.
Sorry. I'd be happy to elaborate a little. Part of the problem in defending the statute was political. We in the Eighth Circuit, got a panel that basically was primed to believe the attacks from the state commissions and the local bell companies that these orders had been written by a bunch of Washington bureaucrats who wanted to preempt traditional state prerogatives. I have to admit that some of the provisions in the act were quite unclear about who was, whether the FCC was making rules about them or not. But again, we focused on the text. Congress put the 96 Act provisions involving local competition into as amendments to the 34 Act. The Section 201B of the 34 Act gives the FCC rulemaking authority concerning everything in the statute. So Justice Scalia, no friend of Washington bureaucrats generally, saw that, the strongest textual argument was that the FCC had the authority to implement the local competition provisions of the 96 Act, notwithstanding the claim that Section 2B was a horse-high, pig-tight, bull-strong, a barrier to it. And so at least there, we were able to use the text to persuade a court to do the right thing, I think. At least a couple of the opinions that came out might be different now after local Wright is overruled Chevron. Notwithstanding what I said a couple minutes ago, the Fifth Circuit panel that heard the challenge to the first universal service order was very skeptical at oral argument about the commission's power to create the E-rate program. And if you'd been at the oral argument, you might have thought it was going to, die in the cradle. We had a three-judge panel that just sort of didn't like it. And in some fairness to them, if you read the text of sections 254, you don't necessarily see a multi-billion-dollar fund, but you do see that the commission is supposed to, quote, enhance access to advanced telecommunications and information service, unquote, as I think has been noted already here. And so our argument in the brief, again, focusing on the text and at the oral argument was, creation of a large fund to support the wiring of schools and libraries would unquestionably enhance access to advanced services. And And here's one where Chevron clearly helped. The court ended the section of its opinion on the E-rate issue by stating that even though the parties challenging the E-rate program had, quote, offered a persuasive reading of the statute, its plain language does not make Congress's intent sufficiently unambiguous for Chevron step one review. And then the next sentence, the only one to say anything good about the FCC's order is, therefore, we defer to the FCC's interpretation under Chevron step 2 and affirm those aspects of the order providing internet services and internal connections to schools and libraries. So, it's true that Chevron may well have some, will have some real world effect or the next time Congress passes an ambiguous statute, which will probably be the next statute it passes.
Thanks, Chris. Earlier panels talked about the deadlines the myriad deadlines that are in the Act. Richard, do you think those were helpful, were not helpful? What was the effect?
Well, if you'd asked me in February of 96, I would have said they're definitely not helpful. They're not helpful at all because it gave us 6 months to do a bunch of, and overall, I think it was 180 rulemakings in 18 months, something like that. But I think I agree with what Gina said in the prior panel. I think that, in fact, they were helpful and they worked. But I think one of the reasons they worked is the statute passed with overwhelming majorities on both sides of the aisle in both of the chambers. And to me, that sent an unambiguous message to the FCC that almost everybody on the Hill wanted these reforms done. They wanted them done quickly and efficiently. And I think that gave momentum. It certainly didn't give anybody any person on the 8th floor some sanctuary to say, oh no, we're going to block this. We're just going to be obstreperous. That didn't work. So in that sense, once everybody agreed on what the goal was going to be, it just was a matter of putting in the manpower and getting the work done and trying to send them orders that could be defended in court. But I think overall they worked.
Great.
I remember seeing your chart, Ruth, that of all those things that had to be done in February, of 1996, and thinking, what a task this is. But I guess, like everybody else, I think it might have ultimately just been helpful to say, okay, well, we got to write this thing and we can't argue about it forever.
Right. And fortunately, although the Common Carrier Bureau did the lion's share of the work, a lot of the rulemakings were actually done by other bureaus.
Yes. I think, the centerpiece of the Act, at least to me, was the local competition piece. And that's the one that had to get done in 6 months. And that, as I said, if you'd asked me in July, I would have said these rulemakings, these deadlines are completely impossible. But on balance, they worked.
Yeah. So, Greg, part of the FCC's core mission is to ensure that communications services reach and benefit all consumers. How do you think that was reflected in the Act, and how did the FCC think about benefits for consumers?
So I think, I'm glad Chris reminded me that it was section 254, because I wouldn't have remembered the section number. But prior to the Act, there was this, implicit subsidies that were washing around inside of the incumbent telephone companies, and, from high access charges, from high business rates, all sorts of things that were trying to keep things going. And what the Act said was, you need to make subsidies explicit. And so to make subsidies explicit meant, wow, we need to actually see what's going on, and to try to make it, that it's clear how much we're spending. Well, now as we've seen, the Universal Service Fund has grown quite large. They did some things that I think weren't great by allowing only interstate telecommunications to be taxed, which is a dwindling share of revenues and things like that. But the idea of making subsidies explicit for a specific goal of universal service is exactly the right thing to do. It's now been switched over, included wireless and now broadband to try to use the same framework to get people online. There are all sorts of various programs. I think the genesis of this was the explicit provision in Section 254.
Thanks, Greg. For the next two questions, I'm going to do sort of a lightning round and ask each of you what your answers are. Looking back, what could we have done differently in the implementation phase? What was successful? What wasn't as successful as we thought it would be at the time? Start with you, Richard Welch.
Well, with hindsight, I guess it was probably inevitable, but I think given the short time frames and the intense lobbying, the commission kind of got caught up in what I would call competition fever. And I guess in retrospect, I wished we had not had as robust unbundling rules as we put in place, because that caused such a big fight and gummed things up. Maybe the Supreme Court probably got it right in my judgment that we might have gone a little too far with that. The other thing is it is just incredible how technology outraises legislation and regulation, and it's almost impossible to predict how markets and services are going to evolve. I'll give a couple of examples. Think about the internet. The internet was nascent when this statute was passed. Despite the protestations of, I can think at least one person who was a Capitol Hill staffer who insisted that they had spoken directly to the internet and had everything taken care of. The statute only obliquely referred to the internet in passing. And look at how it exploded. And within just a few years, it was dominating everything. The other example is, think about the long distance market. That was actually the linchpin of the compromise for the Bells to sign on to the statute, the pathway for them to get in the long distance market. And within a few years, it had evaporated and gone away. It doesn't even exist as a discrete market anymore. But that was what everybody was really worried about back in 1996. So you just can't predict this stuff. It just moves so fast.
Thanks, Richard. Chris?
So I have two answers. One of which is sort of something that I would have changed in the statute if I could, but the points are related. I wish Congress had required the IVEX to show that they can compete in other IVEX outside their territories. If they'd done that, it would have changed the dynamic considerably about things like what unbundled network elements had to be, made available to competitors, because the IVEX would undoubtedly have been required to lease network elements and develop more efficient ways to transfer customers to other companies' switches rather than using their rather than complaining that competitors weren't doing enough. So that's certainly 2020 hindsight. But along with that, perhaps the FCC should not have let Bell Atlantic acquire NYNEX. At the time, there seemed to be a real possibility that Bell Atlantic could successfully enter the New York City market and demonstrate what a competitor would need to compete with an incumbent. And And I think that would have been a very valuable exercise that would have that might have let AT&T and MCI and the long distance companies actually get into local markets rather than get acquired by the box.
Thanks, Chris. Richard?
I don't know. I guess we all wish in some respects the statute had been clearer in some places and in some places perhaps more ambiguous. I think I agree with Richard that perhaps the most important thing that I would draw on today is that the marketplaces and the world communications world we saw in 96 looks nothing like what it is today. And that to me means it's also very hard to take lessons that we learned from the 96 Act and apply them to today's circumstances and hope they'd be effective. And more, perhaps most importantly is, and I think this is something somebody mentioned, I can't remember who, we don't have an agency today that has the same breadth and depth of skill and knowledge about developments like artificial intelligence that the FCC had with respect to communications. And that makes all the difference, because it was that expertise and that experience that I think was the driver behind the commission's ability to implement the statute, ambiguous as it was, within the timeframes in a way that mostly worked, with some exceptions.
Thanks, Richard. Greg?
So I'm going to veer off a little bit from about what, first, I think the role of the states is probably not as well appreciated because, with the TELRIC standard, they could have done a lot with discount rates and other things like that. And we were not very clear about that, which is fine because then they gave them flexibility. The piece that I wish they had done, and maybe we should have focused on more, was the competition from wireless. And wireless at the time was the big competition for voice services. And and now the two biggest wireline telephone companies own the wireless companies, or two of the biggest wireless companies. And I think we could have had, throughout the early time, we would have had more pressure from wireless companies. I mean, I don't think they could be any more pervasive than they are now, but prices might be lower if they were separate companies providing services. And now wireless is coming to 5G and providing broadband services, which will also provide competition to both cable and the wireline telcos that provide broadband services. So I wish that had been more pushed in the interim, this structural separation in some sense. They're pushing the competition.
Right. We have some audience questions. The first one is, what court decisions stand out as being either right on point or quite wrong or surprised you? I guess we'll start with Chris on this one.
Well, let me say that I was quite surprised that the argument that Section 271 was an unconstitutional bill of attainder got any traction at all. I just thought that was outrageous. The only bills of attainder statutes that had ever been overturned were bills that punished Confederates after the Civil War and communists during the Cold War. And the thought that a statutory provision that gave a group of companies a way that had been monopolists a way to get into competition was somehow in that category was just absurd. And we've lost in a district court in Texas, and anyway, we ultimately won in the Fifth Circuit and the DC Circuit. So that was one where justice ultimately was done.
Thanks.
Can I praise Chris right here, Ruth? In that bill of attainder litigation, in an FCC brief, he wrote probably two of the best sentences in a brief I've ever written. It started out something like, this isn't an exact quote, but he said, Up to now, the Bill of Attainder Clause of the United States Constitution has been confined to communists and Confederates. Now come the Bell operating companies. I just thought that was fabulous. And nice alliteration, too.
So I just got to work in that in the DC circuit. Professor Tribe argued on behalf of the box, and he had also testified for the box in front of Congress, saying that they ought to adopt Section 271 as a way to let the box into long distance. And anyway, the key thing about a bill of attainder is that it has to be designed to punish someone. And so I wasn't intending to identify Professor Tribe, but I said I'd like to quote from the box testimony before Congress, 2 sentences, which basically said, please adopt Section 271 so we get into long distance. And then my point was going to be, it's not punishment when you do something that a party asks for. Anyway, before I got there, Chief Judge Edwards, who was presiding, told me, I don't want to hear those sentences. Don't say them. And another member of the panel, just in case I was thinking of saying them anyway, said, I don't want to hear them either. And so I go on with my argument, and Judge Wald says, after about a minute, I'd like to hear those 2 sentences you were going to say, Mr. Wright. And I look at the other 2 and say, okay, I'm going to read them. And I did. And anyway, Judge Edwards wrote the opinion, upholding the FCC's position for the unanimous panel. And he block quoted those 2 sentences in his opinion, but he never thanked me.
Greg, another question from the audience. What are the what do you think led to the death of distance? I assume they mean long distance is a separate market. Wireless competition, de-tariffing, something else?
So this was, I think the very first salvo in this was AT&T's one rate plan that they added in roughly 1998, 97, 98, somewhere in there. They had a one rate plan where all of a sudden you weren't paying difference for a long distance call than a regular call. And that's because they didn't have the same costs. They were able to bundle it all together. And it was, as Richard Welch was talking about earlier, the technology changed so much faster than the regulation. The cost of providing long distance has dropped dramatically. And so, now there's no difference from calling from, from where I am to San Francisco to Washington, D.C. or to Mumbai. It's all the same cost. And it's been technology that's changed it.
Richard?
Yeah, I guess I would just add a footnote. I think another change that happened during that late 90s to the early 2000s was interstate access charges were slashed. I mean, at the time of the act, the originating and terminating access charges were probably a nickel to 10 cents a minute, depending on who the carrier was. And there's no way you could sustain a flat rate service with that kind of a per minute charge. Once those rates went way down, then I think, driven by the dynamic growth in wireless, and wireless wireless only faced the charges on one and not just on one. I think that move eventually displaced the long distance companies in providing a single rate, flat rate service. But the change to access charges had a big impact.
You're absolutely right. And I think that gets back to something I was talking about earlier, which is the explicit nature of universal service. All of a sudden, the access charges, which were providing universal service, you're absolutely right. They went down, and that allowed these prices to be low.
Great. Well, I think we're at time. So thank you all, panelists, and we look forward to hearing the next panel.